Hello students, welcome you all for the class of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 26 and the topic of our today's discussion is Payment of Gratuity Act 1972 and it is the part 2. So the objective of our today's session is help to understand the remaining concepts of Payment of Gratuity Act 1972. The contents of our today's session are rate of gratuity, to whom is gratuity payable, forfeiture of gratuity, responsibility of the employer, rights and obligation of employees, and rights and obligation of the employer. So we are going to start from the rate of gratuity. In case of our Payment of Gratuity Act 1926, okay, the gratuity will be generally calculated, okay, on the basis of the monthly salary drawn by the employees, okay. So for every completed year of service or part thereof in excess of 6 months, the employer shall have to pay the gratuity to an employee at the rate of 15 days wages based on the rate of wages last drawn by the employee concerned. Okay, so depending on the last drawn wages, okay, the employer shall have to pay the gratuity to an employee, okay, according to the rate of 15 days wages. So 15 days wages would be taken into account, okay, while calculating the gratuity of the that particular employee. So last salary, okay, of which 15 days is 15 days wages will be considered, okay, as a basis for calculating the gratuity. Now in case of piece rate employee where there is a piece rate system, okay, in that case the daily wages shall be computed on the average of total wages received by him for a period of 3 months, okay. Employees those who are being working on daily wages for a period of 3 months immediately preceding the termination of the employment, and for this purpose the wage paid for any overtime load shall not be taken into account. So in case of piece rated employees, wherever the employees are working on a piece rate system, so the average of total wages received by him for a period of 3 months will be taken into account, okay, and on the basis of that the gratuity will be calculated. Now in case of employees who is employed in seasonal establishment, okay, who is not so employed throughout the year, okay, the employer shall have to pay the gratuity, okay, minimum, okay, rate of 7 days wages, okay, will be considered to calculate the gratuity of that particular employees those are working in the seasonal establishment. Now in case of monthly rated employees, those who are getting the monthly salary, so 15 days wages shall be calculated, okay, by dividing the monthly rate of wages last drawn by him by 26 and multiplying the quotient by 15, okay. Now this is the formula, okay, gratuity is equal to monthly salary divided by 26 into 15 into number of years of service. Particularly all employees those who are entitled to get the monthly salary, okay, here they will be drawn, they will get the gratuity by using this formula, okay. So 15 days of wages shall be calculated by dividing the monthly rate of wages, okay, last drawn by him by 26 and multiplying the quotient by 15. So in this way, the gratuity of the employee, those who are entitled to get the monthly salaries, okay, in that case the gratuity will be calculated in this sense. The amount of gratuity payable to an employee shall not exceed 3 lakhs, okay, and 50,000 rupees. So 3 lakh and 50,000, that should be according to the old rule. Now, okay, from 3.5 lakh, okay, the gratuity has been increased to 10 lakh, and after 10 lakh, okay, right now uh, most of the employees, those who are be entitled to get the monthly salary, okay, among them they are getting nearly 20 lakhs rupees as an gratuity, okay, particularly in organized sectors. So in this way the gratuity has been calculated. To whom is gratuity payable? Okay, so gratuity would be payable to the employees, okay, employees those have been rendered the continuous service for a period of suppose say 5 years according to this act, okay. However, in case of death of the employees, okay, it shall be paid to their nominees, okay. So whatever their nominees are there or dependents are supposed to be there, okay, that gratuity will be hand over to that particular nominee in case of death of that particular person. We call it is a deceased person or any other dependents, okay. If suppose there are some minors, okay, are supposed to be there, okay, there is no senior person or adult person are supposed to be there, then it should be deposited with the controlling authority, who shall invest the same for the benefit of such minors in the bank or any other financial institution. So whatever form of gratuity has been there with respect to that particular employee, those who are going to be retired, okay, okay, it should be paid to either themselves, okay, or in case of death of that employee, it should be hand over to the its respective nominee or other dependents. Gratuity is calculated on the basis of the continuous service, as we were already mentioned in the previous session also. So minimum 5 years length of service has been considered, okay, in case of organized sector, okay, or those who are getting their monthly wages regularly, or for every completed year of service or part in excess of 6 months at the rate of 15 days wages last drawn. So last in the last month what was the salary that the employees was drawn, okay, its 15 days salary will be considered by using the previous formula, okay, divided by 26 into number of length of or the length of service, okay, that he has rendered to that organization. Depending on that, okay, the gratuity will be calculated. The maximum amount of gratuity according to the new amendments to the employees, those who rendered the continuous service, would be up to 20 lakhs, okay, and which was been increased from 10 lakhs, okay, according to the new payment of gratuity amendment act 2018. So this gratuity has been payable to the all the employees, okay, those who are being regular employees, excluding the apprentices or employees those who are on the training period. Now forfeiture of the gratuity. Now in what circumstances the gratuity will not be given or may be confiscated by the employer, okay. If the employee, those who have committed any sort of misconduct or indiscipline or any kind of willful omission or negligence, okay, on the part of that particular employee, okay, then there will be possibility that forfeiture of the gratuity. So according to section 4 subsection 6a, okay, this will provide the how to calculate the gratuity in case of forfeiture, okay. So this will provide the gratuity of an employee whose service has been terminated for any act of willful omission or negligence causing any damage or loss or destruction or property belonging to the employer. Okay, so any of the aspects, okay, which are being related to omission, negligence, okay, which will be causing to the damage to the property of the employer, okay, in that case the gratuity can be forfeiture. The gratuity shall be forfeited to the extent of the damage or loss or caused. Okay, so how much loss would be there, okay, due to negligence of that particular employee, it should be calculated, and rest of the other amount will be deposited as a form of gratuity to that particular employee. The right of forfeiture is limited to the extent of damage. In absence of proof of the extent of damage, the right of forfeiture will not be available. Now it should be taken into account that what form of damage has been caused to that particular employer. Okay, say for example, it is intentionally he has been committed that particular kind of misconduct or indiscipline or some sort of negligence. Okay, so some sufficient proof has been collected, and depending on the decision would be taken to forfeiture of that particular gratuity of that respective employee. Okay, in case of absence of the proof, okay, there cannot be the forfeiture of the gratuity of that respective employee. So any employer, okay, without any evidences or without any proof, okay, they cannot forfeited the gratuity of that particular employee. Okay, one should require some sufficient proof, okay, what form of causes has been made or damages has been made to that particular employer. So according to section 46b, it deals with the cases where the services of the employee has been terminated, and there will be some particular subsections would be there. Okay, for righteous and disorderly conduct or any other act of violence on his part of that particular employee. If any of the employee, those who are involved in any sort of violences and that may cause to the employer, suppose say his property has been damages or machines or some production activities has been caused, okay, due to his misconduct or indiscipline, okay, or it is a disorderly conduct. In that case, okay, there will be possibility that the employer can be terminate their service, and they will offer they will forfeited their gratuities. For any act which constitute as an offence involving the moral turpitude, provided that such offence is committed by him in the course of his employment. If any of the employee, those who are being involved in any sort of offenses and offenses committed by that particular person, okay, or he will be involving any form of moral turpitude, okay, wherever he is being causing to the organization by damaging the overall image, and he has been intentionally involved in the process of causing the production process. So in that case also that employee's gratuity can be forfeited. In such cases of gratuity payable to the employee may be wholly or partly forfeited. Now it depends on the employer that how much gratuity that they can forfeited. Okay, they can even wholly forfeited it or partly forfeited it. It depends finally on the how much extent the damage has been caused to the employer. So where the services has not been terminated on any of the above grounds, the employer cannot withhold the gratuity due to the employee. Okay, in the above cases, okay, the employer can forfeit the respective employee's gratuity. If the above condition do not meet, okay, then any of the employer, they could not forfeit the gratuities of these employees. Where the land of the employer is not vacated by the employee gratuity cannot be withheld. Okay, if any of the employee, okay, those who have been vacated the land of that particular employee, okay, in that case gratuity can be stopped for a particular period of time. Okay, and once the issues has been get resolved, Okay, after that the gratuity will be given to them. Now in this way, the employer are having the rights to forfeit the gratuities of that respective employee in case of forfeiture. Okay, or any of the employee, they was suppose they was have been willfully involved in the process of destruction, those who are being causing to the property of the employers. Now the responsibility of the employer. Okay, now, when we are talking about the implementation of this Payment of Gratuity Act, okay, 1972, okay, this form of act has been primarily having the responsibility of the employer. Okay, so the prime responsibility over here to provide the information to that respective employee. So all employers other than the employer or establishment belonging to under the control of central or state government shall have, subject to provision of subsection 2, and obtain the insurance in the manner prescribed, or his liability for the payment toward the gratuity under this act from the Life Insurance Corporation of India, established under the Life Insurance Corporation of India Act 1956, or any other prescribed insurer. So each and every employer, they need to protect the individual lives of the employee after the retirement, mm, or whenever whenever the services of the employees are going to be terminated. So it is quite necessary to provide the protection in the form of giving the social security measure. So they would think that, okay, to manage this gratuity, okay, by means of approaching to some of the insurance organizations, and they will generate the insurance fund. So generally they are approaching the Life Insurance Corporation under this Act 1956, okay, and generate the fund for the gratuity, that is called as a gratuity fund. So the appropriate government, they should notified into this official gazette that each and every employer, that they should have to open some account in the Life Insurance Corporation of India as an gratuity fund, and pays their regular contribution by an employer. Okay, so the appropriate government may, subject to such condition as may be prescribed, exempt every employer who had already established the approved gratuity fund in respect of his employees who desire to continue such arrangement, and every employer employing 500 or more person who establishes an approved gratuity fund in a manner prescribed. So employer, those who are employing nearly 500 employees within their organization, so the central or state government has directed to them, they need to approach to the Life Insurance Corporation of India. Okay, and those who have been already applied for a gratuity fund, okay, so for them it is quite okay to open that account over there. Okay, those who are not applied to open the gratuity fund, so they will be instructed to get the approval, okay, by initiating the process of starting the gratuity fund, okay, according to the manners which has been prescribed under the Life Insurance Corporation of India Act 1956. So where the employer fails to make any payment by the way of premium to the insurance, or by the way of contribution to all the approved gratuity fund, okay, he shall be liable to pay the amount of gratuity due under his act, okay, including the interest if any, or delayed payment forthwith with the controlling authority. So after opening the gratuity fund, if suppose any of the employer, those who are not following these rules and regulations by paying their appropriate contribution in the approved gratuity fund, okay, then the controlling authority of that Payment of Gratuity Act, okay, they are having the rights to recover the contribution along with the interest and any other form of delayed payment from the employer. Okay, so it is in the interest of each and every employee where okay, how does that gratuity will be finally calculated and distributed to the respective employee. Whether contravenes the provisions above shall be punishable with fine which may be extended up to 10,000 rupees, or in case continuing the offence for further fine which may be extended to rupees 1,000 for each day, okay, during which the offence continues. Okay, if the employer repeatedly they are conducting this offence in the same way, okay, even after opening the approved gratuity fund, okay, in the life insurance corporation of India, but they are not paying the contribution, okay, that act can be punishable with a fine of rupees 10,000, okay. And even if suppose they are continuously doing the same practices, there will be 1000 rupees each day fine will be continues, okay, until the offense continues. So in this way, it is the responsibility of the employer to maintain the approved gratuity fund by paying their contributions regularly. Now it is the rights and obligations of the employee. Each and every employee of the organization, those who are being aware, okay, to about their rights, so they need to apply for the payment of gratuity, that is called as application of the payment of gratuity. That application of payment of gratuity has been completely mentioned in section 7 and their different subsections, okay. So within 30 days, okay, according to this payment of gratuity act, okay, 1972, the respective employee, those who are going to retire, okay, they need to complete the formalities, okay, within 30 days, okay, even after the date of superannuation or retirement, okay, and they will apply for the gratuity. If suppose the respective employee has been died, okay, during the course of employment, okay, then its nominee, okay, that then its nominee will be considered as an employee who will be eligible for the payment of gratuity in case of death of that particular employee, okay. They would apply for getting the payment of gratuity within 30 days. They need to make an application to the employer. So in this way, the application of payment of gratuity can be done by the respective employee or its dependents, okay, or we will call them as a nominee. Now the rights and obligation of the employer, okay. Now when we are talking about the employer and their respective role, responsibilities and duties, according to section 7, okay, and from subsection 2, 3 and 3a, okay, it has been mentioned over here. This will lays down that as soon as the gratuity becomes payable, the employer shall, whether the application has been made or not, determine the amount of gratuity or by giving the notice in writing in the person to whom the gratuity is payable, also to the controlling authority specifying the amount of gratuity so determined. If any of the employee, those who are not being applied for the gratuity, okay, it is the duty of the employer to communicate that respective employee or even its their dependents, okay, in case of death of the employee, and simultaneously communicating to the controlling authority, okay, they are going to disperse the amount of gratuity, okay, in the respective account. Now, in case of section 7 subsection 3, Act says that employer shall arrange to pay the amount of gratuity within 30 days from the date it became payable to the person to whom is payable. So within minimum 30 days, the employer shall have to act and pay whatever form of gratuity has been supposed to be there to that particular employee. In section 3a, okay, the amount of gratuity payable under subsection 3 is not paid by the employer within the specified period of time in subsection 3, the employer shall pay from date which the gratuity becomes payable to the date on which it is paid simple interest at the rate of 10% per annum. If the employer has been intentionally delaying the amount, paying the amount of gratuity to that particular employee, okay, that respective employee are having the rights to make an appeal to the controlling authority. Okay, if the controlling authority will direct the employer, okay, these employer shall have to pay whatever form of payment of gratuity to that particular employee, okay, at 10 at an interest, okay, simple interest at the rate of 10% per annum. So payment of gratuity plus 10% per annum, okay, from the date of which the gratuity becomes payable to that particular employee, it should be calculated, provided that no such interest, okay, shall be payable if the delay has been payment is due to the fault of the employee and employer has obtained a permission in writing from controlling authority for delayed payment on this ground. Okay, if any of the employee, those who are being make an complaint, okay, the employer has been delaying that particular payment of gratuity, okay, the respective employer asks the explanation to the controlling authority. So controlling authority will direct that respective employer to pay their gratuity along with 10% interest. Now there are some other rights and obligations of the employer, okay, that is called as dispute to the amount of gratuity and admissibility of the claim. Okay, if whatever form of claim has been supposed to be there with respect to the gratuity, okay, if it has been not admissible by that particular employee, even the employer has not taken it very seriously. So okay, so in that case, the respective employee can go to the controlling authority and ask for the explanation over here. So if the claim of gratuity is not found admissible, the employer will shall issue the notice to the prescribed form to the applicant employee nominee legal heir, as the case may be, specifying the reason why the claim of gratuity is not considered admissible. Okay, particularly if the employee has been applied for claim, okay, and suppose his claim has been get rejected, so in that case it is the duty of that respective employer, whatever form of claim has been supposed to be there, why that claim has not been admissible by the employer, a copy of notice shall be endorsed to the controlling authority. Okay, its other duplicate copy will be also sent to the controlling authority to that respective employer. Okay, but even the employee in this case, okay, they will ask for the explanation from the controlling authority why these gratuity will not be given to that respective employee. Recovery of gratuity according to section 8, okay, that section 8 will provide that if the gratuity payable under this act is not paid by the employer within the prescribed period of time, the controlling authority shall an application made, okay, in its behalf by the aggravated person and issue a certificate for those amount to the collectorate, okay, who shall recover the same sum together with the compound interest thereon, such rate as a central government may be notification and specifying from the date of expiry of the prescribed time as arrears of land revenue and pay the same to the person entitled thereto. If any of the employer, okay, those who are not obeying the instructions of the controlling authority according to section 8, okay, and the employee has been mark an application to the controlling authority, okay, if the employer has been rejecting the claim of that particular employee, in that case, okay, the respective employer shall have to pay whatever form of payment of gratuity according to the compounding interest. Okay, so whatever from the date of claim has been admissible from that particular date to the disbursement date, okay, that compounded interest would be get applicable. So even whatever form of gratuity has been there, it should be calculated, okay, and its recovery has been done from that respective employer and hand over to the respective employee. Protection of gratuity. So gratuity has been exempted, okay, and attachment in the execution of the decree or amount of a order of any civil, revenue or criminal court. It has been the payment of gratuity has been exempted from the execution, okay, from decree or order of any civil code. It does not comes under any form of civil code, revenue code or criminal code. The relief is aimed at providing the payment of gratuity to the person or person entitled thereto without being affected by any order of attachment by the decree of any court. If any of the employer, those who are being indulging any sort of activity, so the controlling authorities are having the rights to protect the amount of gratuity and hand over that gratuity to the respective employer. So this relief has been aimed in providing the payment of gratuity to that particular decree of persons. Okay, so whoever has been applied for the claim, okay, that claim could be get protected under the payment of gratuity act. So that's all about our today's session. Thank you very much.